Hello, my beautiful people. How are we doing today? Back with you with another study session. Now, I have been hearing this. A lot of questions have been coming to me about suing the furniture. Now, there are a lot of things when you're going through your administration process. I try not to mix the private with what I do with credit, with like teaching you how to fix your credit, but there is a process when you're trying to sue or you're trying to get remedy, especially if your remedy is trying to get something deleted or you trying to get monetary relief. So there is a process that you have to do, and please do not uh, try to go through this process fast. If you want it done right and you want it to end in the way that you need it to, especially with the remedy that you're looking for, you must go through this process and you must be patient. Nothing happens overnight. Okay. I do want to state that I am not an attorney. I am not a financial advisor. If you need anything of that nature, please consult a lawyer, consumer lawyer, or consult your financial advisor. Everything that I say on this video or on my platforms, if you visit those, the information is for educational and entertainment purposes only. Okay. So please do your research. Please do your research. So suing the furniture, I call it furniture slash creditor because you need to know that a creditor can be a furnisher. All right. Those are the entities that report this information to your consumer reporting agencies, your CRAs, TransUnion, Equifax, and Experian. They report that information, so they're furnishing that maybe that negative derogatory information. So they're furnishing all the information, whether it be good information or derogatory information. All right, so let's move on. All right, when we're suing the furnisher, you need to understand that it is the responsibility of the CRA and the furnisher to provide verified, accurate, and complete information to your consumer credit report. All right. So according to 15 USC 1681 S2B1, this is where we hold furnishers liable. Now, a lot of consumers would try to they would try to go to court and sue, maybe arbitrate for this law right here, 1681 S2B1. And they never get the outcome that they want because they're approaching it different. You can't sue if you go to a consumer attorney, they'll tell you that you just can't sue under 15 USC 1681 S2B1. But I will tell you, if you go through this process that I'm about to take you through in this study session, you can sue under this exact law because you have went through the process. You've done the necessary steps. Okay. All right, so when you're trying to sue the furnisher, you must dispute with the CRAs, the Consumer Reporting Agency, first under the FCRA, which is the Fair Credit Reporting Act, for especially under 15 USC 1681 S2A. This law gives this is the responsibility of the furnisher to report this accurate information, and they have to go through reasonable procedures to do that. So if you want to get remedy, if you want to get anything deleted, please go research this law, check out this law, learn it for yourself so you can understand the process, and you can come back to this video and go back through it, and you'll understand what I'm trying to say. Okay. So now I know a lot of credit gurus will tell you stop trying to attack the CRAs first, which is fine when you're trying to get something deleted. That's fine when you're trying to get something deleted. But when you're trying to sue, when you're trying to get monetary remedy, and if you went through the actual furniture first, and a lot of times you're gonna hit a roadblock. They're not gonna delete anything. You can send them that letter, that notice, and sometimes they'll respond back, letting you know that that's accurate information, or they'll send you copies of a bill, and also if you request it. But sometimes you won't get a response at all. And the only thing left to do when you approach that aspect is to sue, because the only way that you can communicate with a business is that you have to use the law to get them to move and do what you want them to do. So this process, you came to the right place. Make sure you hit that like and subscribe button. Turn on notifications bell so that you can stay up to date with my videos that I post up, or whatever I place on my I post on my social media platforms. So to sue a furnisher or the furnisher, you must dispute through the CRAs first. What this does is when you sue, when you dispute through the CRAs first, this sets off the liability of the CRAs to provide verified, accurate, and complete information. So now, when you run this play, this is what I call the play. When you run this play, the CRAs and the furniture are liable. You can sue both if you run this play correctly, okay, and get your remedy, whether it be deletions or monetary remedy, or it can be deletions and monetary remedies. All right, so you want to dispute with the CRAs first, put them on notice first. Now, you can also, when you send this letter, or this notice to the CRAs, you can also send it to the furnisher at the same time, okay? But make sure you put this dispute in play with the CRAs, okay? So that when the CRA contacts the furnisher, then they'll have a copy of your notice and they'll see that you're trying to dispute an item. So you want to dispute through the CRAs first, and this sets off the liability of the CRAs. And if you were to try and go get you some legal representation, they will tell you this. The first thing they will ask you is, did you dispute with the CRAs? Um, I I've seen it a number of times where some of my clients will contact me and say that the contacting the furnisher didn't work. So use this process to dispute with the CRAs first. All right, so step two, the CRAs, once you dispute with the CRAs, they will have to notify the furnisher or creditor of this dispute. Okay, they will have to notify the furnisher or creditor of the dispute. Now, next, the furnisher will have to respond to the CRAs with the appropriate information, whether it be accurate or inaccurate, however you want to see it, they have to respond to the CRAs. Okay. And fourth, the CRAs will have to respond back to you with a result of verified as accurate or inaccurate. So here's an example of a after an account was being investigated or disputed, to where this and this is from TransUnion, where they verified that this count was accurate. You could take a look at some of the things like the date open. You could take a look at the date paid. Look at the high balance. So when you're looking at this, it's best to look for errors, because you can use this as leverage when you're trying to get this account deleted. Okay. Getting monetary remedy is a plus, it's a bonus. But when you're trying to get this account deleted, now that you contacted TransUnion and you disputed the account. Then TransUnion contacted the furnisher. They got the information from the furnisher. And now they're contacting you back, letting you know that the account was verified as accurate. Now, this account was written off in bankruptcy, and it's showing that it was date paid. So if it was showing that a date paid, it's not showing, and the account was open in 2016. Where is the information from 2016? There's no payment history for 2016. There's no data information. They didn't even list it, no ratings for 2016. That right there is an error already. All right. So once TransUnion or once the CRA comes back to you as verified accurate, then and you know for a fact you got they're reporting errors, you got them. You got them, okay? This is how you set that trap. This is the play. Now, what I do want to reiterate to you is, do not try to shortcut this process by going straight to the CFPB. Because as a bonus, at the end of this study session, I will show you a case law where someone tried to use that method, but and it didn't work out for them. So do not try to shortcut this process by going straight to the CFPB. That's the Consumer Financial Protection Bureau. It can be done, but you do not want to give the furnisher a reason to say they were not notified directly. So the key to this is to notify them directly. Okay? Notifying them directly. You do not want to go through the CFPB. When you sent that notice to TransUnion, and I told you that you can also send that notice to the furnisher, this is what I mean by directly. Okay. Now, I also stated finding errors. You want to find errors. This is like another layer of not like protection, but it's another layer of trying to get this account deleted. So when you're finding errors in credit reporting, they have to make sure that they're doing or providing reasonable procedures for these investigations. Because we know as consumers, we can sit here and dispute an item and the item gets deleted and then turn around and it pops right back on your credit report. Or you're disputing an item and the item doesn't get deleted at all and they just come back to you and say verified without even giving you no proof, telling you anything about, how this account was reported, the type of information that was sent to the CRA. They didn't use reasonable procedures. But when you go through this process, this is how you catch them in a lie, by putting the furnisher and CRA on notice about the reporting errors. You can catch them in a lie by not following reasonable procedures to provide accurate and complete information. So when you're sending these notices, and also include, if you see any errors, please take screenshots of your credit report, mark them up if you have to, make a list. And when you make your list, this is another key, hint hint, always put it in the form of a question when you're identifying your errors in that credit report. How is this account paid when you're showing that you're showing a balance? How was this account opened in 2016, but it doesn't fall off my credit report until 2025? So ask those types of questions, okay? Because the account shouldn't be on your credit report no more than 7 years. Really, it's 7 years and 6 months to be exact, okay? So you want to try to find errors. This is another layer of I'm gonna say protection or leverage to help you get these accounts deleted. All right, so now when you're trying to sue a furniture, you also got to think about this. How were you damaged? You must be damaged in order to sue. You must be damaged in order to sue. So 15 U.S.C. 1681 S2B1 states that duties of furnishers of information upon notice of dispute after receiving notice pursuant to section 1681 IA2 of this title of a dispute with regard to the completeness or accuracy of any information provided by a person to a consumer reporting agency, this person shall, now this is what they're required to do by law, conduct an investigation with respect to the disputed information. Okay, you disputed it and they got to check into it. Once the CRAs contact them, they have to conduct that investigation. They have to review all relevant information provided by you, the consumer, provided by the consumer reporting agency. They must also report the results of the investigation to the consumer reporting agency. And if the investigation finds that the information is incomplete or inaccurate, they must report those results to all consumer reporting agencies to which the person furnished the information and that compile and maintain files on consumers on a nationwide basis. So this is how you get both. You know that these are inaccuracies on your credit report or errors on your credit report. They come back to you with this bogus result stating that it was accurate or verified as accurate. Now that's when you'll go to pursuing your lawsuit, because now you're holding the CRA liable and you're holding the furnisher liable. Now you can also submit a complaint. I would say do this because this is also another way of showing that you are putting them on notice. You're putting both of them on notice. If I were you, I would file the CFPB complaint, and towards the end of the CFPB complaint, it'll ask you, do you want to add any other companies to your complaint? And you say yes, and you're going to add the complaint is going to be with the I'll say furnisher, and then you can include TransUnion and Equifax or whoever else is that you want to add to. I think they let you add up to three companies, if I'm not mistaken. You can add up to three companies to their complaint. You can put them all on notice in one complaint with the CFPB. Now, if you want to take the route with the CFPB complaint, and do it with the CRA first, then yes, you'll do three separate ones. You'll do one for TransUnion, and you'll include the furnisher. You'll do one with Equifax, include the furnisher, or whatever CRA. Just make sure you include the furnisher /creditor, so that you can put them on notice and and that's also letting the furnisher know that you're making this complaint. You're showing, you're putting the CRAs on notice also. Okay. Now, once you file the CFPB complaint, and you can go, you don't have to do the CFPB complaint if you don't want to. You can go straight to attorney, because they have to by law, they have to provide accurate, complete, and verified information. And when you went through that process of disputing with the CRAs and also including the furnisher, then there are reasonable procedures that they're supposed to take. And when they didn't do that, and they kept the account on your the derogative, I'm gonna say derogative account on your credit report, they're violating the law. So you can go straight to an attorney. And through my process of getting my credit improved and disputing with these companies, it was really, really hard for me to find an attorney that actually dealt with FCRA violations. So to help you out, I included NACA, whatever you want to call it. I did make sure you look at the website. Go type in your state, and they will pull up a list of attorneys that can help you and that actually practice in FCRA, FDCPA, and you can contact them directly. They'll give you pictures. You'll see the phone numbers, addresses, emails. So that's one way that made it a whole lot easier for me in looking for an attorney, because here in Mississippi, is the attorneys are pretty much, they like to deal with bankruptcy cases. They, to be truthful, bankruptcy cases are the easiest to attack because there's so many laws when it surrounds a bankruptcy. But when it's talking about um, errors in your credit report and disputing with the CRAs, it's really hard to find an attorney, a consumer attorney, that deals with that. Okay, so try NACA, use that to help you find an attorney. Also, if you don't want to go the attorney route, you can do arbitration. Now, there are some fees associated with the American Arbitration Association and JAMS. Now, I do think that American Arbitration Association, I think the fee is like $200. I think JAMS is just a little bit higher, but you can use this route to take matters into your own hand. Only, I say, use arbitration only if you follow this process, because if you don't go through this process, I would hate for you to have to go into arbitration and you didn't go through those necessary steps. Okay, because in arbitration, those are retired judges. Those are some lawyers that still practice, but those are it's like an out of court way of settling your case. Okay, and you can get monetary remedy, you can get deletions, you get whatever you want. Just make sure you request it when you filing your arbitration papers. I also have a study session on arbitration inside of my videos on my YouTube channel. So please like and subscribe. Turn on that bell, that notification bell, so that you can stay updated. But you can go watch that video to help you out with it goes more in depth with the arbitration process. Okay. All right. So now I did tell you that I was going to give you a little bonus. So I always like to fact check anything that I'm disputing. I like to fact check it with case law, because when I send off my disputes, I include these cases inside of my disputes, because I want them to know that not only am I an informed consumer, but there are case laws out here that substantiates my claim. Okay, so but the thing about it is, the reason why I did this whole study session is because in this particular case with Edie's versus Wetzel in the federal Third Circuit, this is a federal case. This person, which was actually a inmate of a prison, he was affirming the dismissal of an FCRA claim, noting that a consumer cannot maintain a 1681 S2B claim based on allegations of a furnisher's pre-notice conduct. So what it was, he went straight to he didn't put the he actually put, if I'm not mistaken, he put the furnisher on notice first. He didn't go through the process of contacting the actual CRAs. So my whole point is to dispute with the CRAs. You can also include the furnisher in it. You can send them the same exact letter, but dispute with the CRAs first. Okay, so that's what he did, and he actually didn't win this case all because of the process that he used in disputing this actual account. So you can go back and read it, find it, research, do study. Always study when you're doing something. That's the best way to at least understand your process, to at least understand what's going on. And then who knows, when you learn this process of getting your remedy, of getting accounts deleted, you can help somebody else, especially somebody else in your family. And we see them suffer every day, and this is one way to help yourself and one way to help your family. All right, you can contact me via YouTube. I always respond back to my comments. I'm on TikTok, I'm on Instagram, I'm on Facebook, The Secret TLC. That's my Facebook group. We do a lot of communicating and collaborating. I do have a Consumer Scholars University where, like a lot of gurus, credit gurus, they have these letters and templates, which letters and templates are fine. And I do understand that a lot of people that do not know how to write a letter, do not know how to respond, don't know what to say. The letters do come in handy. But I will always say the only difference between me and the other credit gurus is that I don't do credit repair. I'm in the business of teaching you how to repair your own credit, DIY credit. So instead of me just giving you a website link to where you could go buy purchase the letters or the templates, mine are actually in the form of a course. So when you get the letter, you're not just going to get a letter. You're going to get a course that shows you exactly how to formulate your letter. It tells you what's inside the letter, tell you why you're using it. It's like a guide. When you don't have access to me, doing the Consumer Scholars University is the best way to get that extra help that you need when you're sending off those templates. Okay. All right. So thank you, fam. That's it for this study session. And if you want to contact me, you can text 504-517-5098. Ask me any question that you like. Join in on my lives on my Facebook group, The Secret TLC. And y'all have a blessed day.